chairs of the Holland and Hart Health Law Group, and welcome to our program today on recent HIPAA enforcement key issues to consider. We're going to move through these issues relatively quickly today because I know that you're all busy. A couple of preliminaries. You should have received a link from Laura that would include the PowerPoint slides. In addition, we've got several articles that are available. I can have Laura send those out via a link to those who participated. Alternatively, they're available along with all the other HIPAA articles that we've authored on our website at our healthcare website. So if you go to that link there, you can access these articles that are relevant to our discussion today, as well as other articles. If you have questions during the program, we won't take questions during the program because we're recording it. But feel free to submit those using the chat feature or the Q&A feature, or just shoot me an email offline, and I'll go ahead and respond to those questions offline. With that said, let's talk about HIPAA. By the way, it's HIPAA, not HIPPA. It's short for the Health Insurance Portability and Accountability Act. As you all know, there are different parts of HIPAA. There's the privacy rule, security rule, and the breach notification rule. And then as part of the economic stimulus package back in President Obama's age, they passed the HITECH Act, which included a bunch of provisions that modified HIPAA. Those were summarized and the final rules implemented in the omnibus rule that came out in 2013. I wanted to just go over that briefly just so that you're aware that there really have not been any new regulations dealing with HIPAA since 2013, but there has been some guidance, litigation, and some settlements. Those settlements are what we want to talk about today. Before we get there, though, remember that when we're talking about patient privacy, HIPAA establishes the floor of patient privacy on a federal level. To the extent that there's another state or federal law that offers more restrictive provisions or gives patients greater rights to access their information, then you've got to comply with that other law. But HIPAA is at least the floor. One example of other laws that are more restrictive would be those laws in 42 CFR Part 2, the rules concerning federally assisted substance use disorder programs. So just remember that although we're going to be talking about HIPAA today, that you're aware of other laws in your state or that may apply to your particular organization that may be more restrictive. So let's talk about the enforcement over the past year. The first lesson that we learned is the government is more active in HIPAA enforcement, more so than any other year that I've seen since I've been doing this. I think over the past year, they've implemented or come up with HIPAA settlements in approximately 25 or 30 different cases. Those settlements range from anywhere from $6.85 million down to about $10,000. It ranges from large health systems or health insurers down to just very small solo practitioners. Nobody is necessarily exempt. It applies to covered entities. It also applies to business-associated covered entities, so they've been subject to penalties. In addition to the traditional type HIPAA settlements, the government has also implemented its right to access initiative. And so far there have been, as of just this morning, I got word that they have the 12th settlement in the right to access initiative. So we'll talk a little bit more about that in just a minute. Those settlements arise because of the HIPAA civil penalties that can be imposed if you violate the HIPAA privacy, security, or breach notification rules. The penalties that can be imposed depend upon the type of conduct that's involved. The penalties range from anywhere from $119 per violation up to $59,000 per violation. Now, the key here is understanding the mens rea or the bad conduct that's involved. The bad news is if you act with willful neglect, then it's a mandatory penalty of at least approximately $12,000 up to approximately $60,000 per violation. And those figures are adjusted each year. I haven't seen the numbers for 2021 yet, but the numbers right now for 2020 are for willful neglect, mandatory fine of at least $11,000, $11,904 up to $59,522 per penalty. That's up to a cap of $256,000. That's if you correct the violation within 30 days. If you don't correct the violation and you act with willful neglect, it's a mandatory penalty of at least $59,000 per violation, up to a total of $1.75 million per type of violation per year. So the key here is to make sure that you avoid willful neglect at all costs, because if you don't act with willful neglect and you correct the situation within 30 days, that is an affirmative defense to HIPAA penalties. They can't impose HIPAA penalties under those circumstances. Now, you may be subject to other penalties or consequences for the HIPAA violations. For example, HIPAA authorizes state attorney generals to bring lawsuits. In the future, as part of the HITECH Act, they authorized or allow individuals to recover a percentage of the penalties that are assessed against you if they turn you in and the government comes up with the penalties for that. We don't have the final rules implementing that yet, even though HITECH Act has been around for a long time. So that is not in force right now, but it could come down the pipe at any time, I suppose. In addition, you have an affirmative obligation to sanction employees who violate HIPAA. So even if you're not worried about the government coming after you, you've got to be concerned about your employer coming after you. And you have an affirmative obligation to self-report breaches of unsecured protected health information. We'll talk about that later. Obviously, those self-reports could result in further private action or further government investigations and the like. Now, there is no private cause of action under HIPAA, so a patient can't sue you for a HIPAA violation per se, but creative plaintiffs lawyers out there, they may be able to establish that HIPAA essentially is the standard of care, and if you violate the standard of care, you might be liable in negligence or negligence per se or some other theory based on your violation of HIPAA. So there's a lot of other creative horribles that can rain down upon your head in addition to the civil penalties, but for purpose of today, we're going to focus on those civil penalties. The second lesson from all of those enforcement actions that you need to remember is that you can avoid HIPAA civil penalties if you don't act with willful neglect and you correct the situation within 30 days. So your goal as a healthcare provider or covered entity or a business associate is make sure you don't act with willful neglect. And if there is a problem, that you respond to that, correct it within 30 days. Well, how do you avoid acting with willful neglect? Well, there's certain things that you should be doing, including you make sure that you have the required policies and safeguards in place, that you execute your business associate agreements, that you train your personnel and document your training, that you respond immediately to mitigate and correct any violation, and you timely report breaches of unsecured protected health information if it's required by the breach notification rule. We're going to talk a little bit more about each of those today in the context of these penalties. Third lesson is cybersecurity. This is the biggest threat out there right now to HIPAA issues, to your exposure for penalties for HIPAA violations. You may have seen this report from just this September where there is yet another cyber attack against a major hospital system. When you look at this settlements over the past year, the biggest ticket items all involve cyber attacks, where hackers have gone in and accessed information, may have used phishing in order to upload ransomware or other situations. For the first time, I don't remember this ever happening, but on October 29th, the HHS actually sent out a cyber alert warning healthcare providers of an increased ransomware activity, that they had credible threats that foreign and other actors were ramping up their attacks against the healthcare industry and warning healthcare providers that they needed to make sure that they took steps to protect themselves against these attacks, including ransomware attacks using TrickBot or some of the other programs that are out there. If you haven't looked at this yet, you'd ought to go to that guidance that came out from the OCR, that warning. That warning will take you to the link to the government agency that will provide you with a bunch of technical information concerning these perceived threats that are out there right now that hopefully you are addressing. Ransomware, of course, has been the bane of healthcare entities' existence, or certain entities' existence, for some time now. Years ago, you may remember that the OCR, there was, when ransomware first started coming out against healthcare providers, the Office for Civil Rights sent out a fact sheet dealing with ransomware and how that implicates HIPAA. According to the guidance that the government sent out, if you are subject to a ransomware attack, and for those of you who don't know, a ransomware attack is where a hacker goes in and deploys malware that encrypts all of your data. And in order to get your data back, you need to pay off the ransom. and hopefully you get your data back. The Office for Civil Rights said that a ransomware attack is a presumptive HIPAA breach, even if they may not have, you don't have information suggesting that they actually accessed your data. The government said that if they deployed that, if they encrypted the data, they have used your data, and therefore that would be an impermissible use under HIPAA that would require breach reporting to all of your patients who are affected by that, as well as to the government. That would require you to spend substantial funds in investigating and providing that notice. And, of course, there's going to be a lot of fallout from the government investigation once you do that, where the government may be able to come back in there and determine whether or not you had deployed the appropriate security safeguards to protect yourself against that ransomware attack. Ransomware is such a problem that the joint agencies actually issued a ransomware guidance for healthcare providers and other entities a few years ago. That's available at that website that's up there. This guidance provides some best practices for protecting your network, as well as some advice on how to respond to ransomware attacks. In 2018, the government also issued this Health Industry Cybersecurity Practices Guide. This is a very helpful guide in which they identify the top 5 cyber threats to healthcare industries, including email phishing attacks, ransomware attacks, loss or theft of equipment or data, insider, accidental or intentional data loss, and attacks against connected medical device. In this guide, if you haven't looked at it yet, you really should. It contains best practices for how to address each of these threats. It includes sample forms and additional resources that are available to you to help combat against these cybersecurity threats that you might have. And if that were not enough, just this summer, the government implemented its HC3 home web page that is geared towards cybersecurity in the healthcare sector. Again, if you haven't looked at that yet, you really need to go on there. It, among other things, will contain summaries of different sector alerts of pending threats that are out there against the healthcare industry, threat briefs, and things like that. So that's another helpful resource for you. The OCR has been made it clear that, hey, if you didn't get the word already, you've got to take cybersecurity very seriously. Director Severino said specifically in the settlement agreements, hacking is the #1 source of large healthcare data breaches. If covered entities don't invest the time and effort to identify their security vulnerabilities, be they technical or human, hackers will. The healthcare industry is a known target for hackers and cyber thieves. The failure to implement the security protections required by the HIPAA rules is inexcusable. Bottom line here is not only for HIPAA compliance, but to protect your organization, to protect your patients, you need to make sure that you put in place the protections to guard against these cyber attacks. If you don't, and you have you're a victim of a cyber attack, you have a significant incident, then chances are you're going to have to do a report to the government, and the government will come in and look very critically to determine whether or not you complied with the rules that require you to protect against those, primarily the security rule. So that brings us to the 4th lesson, and that is the importance of the security rule. When you look at the large ticket settlement cases over the past year, almost all of them deal with security rule compliance issues. The vast majority of those do. Why is security rule such an important thing when it comes to the HIPAA penalties? Well, for each person whose information was improperly accessed, used, or disclosed, well, that is a separate violation. So if you've got a cybersecurity violation or another security breach, that usually is going to implicate, hundreds, if not thousands, of patients, and therefore the penalties can add up really quickly, just as shown by the recent settlements that have come out based on security rule violations. The security rule is not only designed to protect the confidentiality of your information, but it's also designed to protect the integrity and the availability of it, so that if and when you need it, you've got it available to make sure that you can continue to operate, continue to provide effective care, that information is available. The security rule generally requires that you perform your risk assessment, that you implement the specific administrative, technical, and physical safeguards, and you execute business associate agreements. That risk assessment is a common factor that's cited in the recent settlement enforcement actions. A lot of those, among other things, they cited the entity because the entity had not done adequate risk assessments to determine what their system vulnerabilities are. The HIPAA security rules specifically require that covered entities and business associates conduct and document an accurate and thorough assessment of the potential risks and vulnerabilities to the confidentiality, integrity, and availability of the PHI. I've listed some elements cited by the OCR that should be addressed in that risk assessment. That risk assessment is not a one-time deal. It should be an ongoing process, probably at least annually, because your security systems, your electronic health data systems will change over time, right? You'll have new equipment, you'll have new software and the like, and therefore it should be some kind of an ongoing process. If there is a significant security breach, the government's going to want to see your risk assessment to determine whether or not you did an appropriate risk assessment to identify and address perceived risks. You're going to want to make sure that you have that available for them. The government this past summer issued its updated security risk assessment tool. So if you don't want to pay, $10,000 or $20,000 for a consultant to come in there and do that risk assessment for you, you can actually go on there to the government's tool here and walk through the steps, and it will help generate an evaluation of your risk assessment. So that's a good tool for all of you. If you haven't looked at that yet, or you would like to compare it to the risk assessments that you've been doing, then there it is. It's available to you on that website. After doing that risk assessment, you also have to make sure that you're complying with the security rules safeguards. That means you have to have in place the required administrative, physical, and technical safeguards that are outlined in 45 CFR 164.308 to .312. We're not going to go through those today, but you're going to want to make sure that you touch base with your information security officer and that you are up to date on the security rule compliance. The government has issued a lot of guidance for security rule compliance. Again, on the HHS website, the OCR website, there's a bunch of materials, including technical guidance, NIST standards, practical suggestions, and the like. The government's Health IT website has additional tools and templates to help you comply with the security rule. Just a word about mobile devices. This is a hot topic right now and really a vulnerable spot for a lot of healthcare providers. It's such a problem that healthit.gov has a specific website dedicated to mobile devices and what you need to do in order to secure your mobile devices. The Office for Civil Rights Director Severino, in some of those settlements that came down this year, emphasized that all healthcare providers, large and small, need to take their HIPAA obligations seriously, particularly their security obligations. The failure to implement basic HIPAA requirements, such as an accurate and thorough risk assessment and risk management plan, continues to be an unacceptable and disturbing trend within the healthcare industry, with specific reference to the loss or theft of mobile devices, laptops, USBs, phones, smartphones that have protected health information on it. Director Severino said that laptops, cell phones, and other mobile devices are stolen every day. That's the hard reality. Covered entities can best protect their patients' data by encrypting mobile devices to thwart identity thieves. Because theft and loss are constant threats, failing to encrypt mobile devices needlessly puts patient health information at risk. We're going to talk a little bit more about that later. That encryption not only applies to your mobile devices, as well as your other devices that store electronic protected health information, but just a word about communicating via email or text, because that encryption standard also applies to electronic data that you send via the internet or via text. The general rule is that any electronic protected health information has to be encrypted. Now, the rules are slightly different depending on whether you're sending that or having that communication with the patient or other third parties. If you're communicating with the patient or the patient's personal representative, one of the HIPAA rights allows the patient to request communication at alternative locations or by alternative means. And the Office for Civil Rights has interpreted that to mean that a patient can request that they receive electronic protected health information via unsecured methods. So if, for example, you wanted to communicate with a patient via unsecured method, just over general email or over a text, you could explain that to the patient that, hey, we can communicate with you via this unsecured method. Just know that it's not secure and it may be subject to outside use. As long as the patient agrees to that, then you can go ahead and communicate with them via unsecured texting or emails. If the patient doesn't agree to that, then you're supposed to encrypt that. Now, that's for communications with the patients. That doesn't necessarily apply to, well, it doesn't apply to communications with providers or other staff. I know it's really common for physicians to text orders or to text information or to send images via unsecured networks over, to their smartphone, for example. Generally, that would be a HIPAA violation because the HIPAA security rule generally requires encryption as an addressable standard. So make sure that you're up to date on your communication issues. Next item is don't forget about the basic HIPAA privacy issues, including complying with the general use and disclosure rules under HIPAA. As you know, that under HIPAA, to use or disclose protected health information, you generally have to have one of the following. Either that use or disclosure has to be for treatment, payment, or healthcare operations, or you have to fit within a HIPAA exception. Another HIPAA exception would be you can make disclosures to family members and others involved in the patient's care so long as the patient had an opportunity to object and they didn't object and you otherwise limit the scope of that disclosure. In addition, there are certain exceptions under HIPAA for disclosures for certain public, safety, and government functions. Unless you fit within one of those HIPAA exceptions, then you generally have to have a HIPAA-compliant authorization. Again, some of those settlements this past year involved kind of basic HIPAA blocking and tackling, things that people just messed up on, even though it's been around for forever. Things like sending patient information in envelopes where they could see the patient's info, or sending information to the wrong email address, or things like that. So just make sure that you remember to comply with those privacy rule requirements. In the interest of time, I'm not going to go through those. I know that you're familiar with those basic rules. I did want to touch base briefly on marketing, though, because I think that there's a lot of misunderstanding. The general rule under HIPAA is you have to have the patient's authorization to engage in marketing, to use or disclose their protected health information for purposes of marketing. The key, though, is to understand what is marketing as defined in HIPAA. Marketing in general means any communication about a product or services that encourage a recipient to purchase or use the product or service. That's the general definition. But the rules differ depending upon who's doing the marketing and what it's for. General rule is, if you're going to use or disclose a patient's information in order to encourage them to purchase another item or service, you need the authorization. But there's a couple of exceptions. The first is, if you are going to use or disclose that information for purposes of treatment because you're recommending a certain item or service that's for treatment for the patient or for your healthcare operations as part of care coordination or the like, or you're describing your own product or service, then that's not marketing within the HIPAA. So you can use or disclose the patient's information to market your own or to share information about your own product or service unless you're receiving financial remuneration to make that communication. If somebody's paying you to make that communication about your product or service, then it comes back into the definition of marketing and you need the patient's authorization. There's another exception that you don't need the patient's authorization to use or disclose information for marketing if it's involved in face-to-face communication with the patient, not phone calls, not faxes, not texts, but face-to-face communications, or if you're simply offering a promotional gift of nominal value. You may want to talk to your marketing people, make sure that they understand the limits on your ability to use or disclose protected health information for marketing purposes. Also remember that even if HIPAA allows you to use or disclose the information, you can't use more than is minimally necessary for a permissible purpose. Now, that minimum necessary standard doesn't apply to disclosures to the patient or their personal representative, to another provider for treatment purposes, per the individual's authorization or as required by law. But in other contexts, generally, you can only disclose the minimum necessary for a permissible purpose. As part of that minimum necessary standard, you need to have role-based access policies where you've gone through and you've identified the persons in your organization who should have access to the information and what information they should have access to. So if you have employees who are out there who are snooping, improperly looking at information they don't have a need to know, well, that should be prohibited by your role-based minimum necessary standard. Now that brings us to COVID waivers. COVID's on everybody's mind. Hopefully it's not in your body, but the general rule is that despite the seriousness of COVID, HIPAA still applies. So the HIPAA privacy and security rule generally apply despite COVID. That means you generally can't disclose a patient's COVID information unless you have the patient's or their personal representative's authorization, or that use or disclosure fits within another HIPAA exception. For example, the disclosure is necessary for the patient's treatment, payment, or healthcare or healthcare operations, or that disclosure, and maybe the disclosure is necessary to avert a serious and imminent threat of harm. Now, the government in February and March, they issued specific guidance that said, hey, just because COVID's out there, we're concerned about it, but HIPAA still applies. And they did talk about some of the potential exceptions, including disclosures to avert serious and imminent threat of harm, disclosures that may be required by law, or disclosures to public health agencies like to your local Department of Health or things like that. But the government didn't say that each and every disclosure of COVID-related issues necessarily triggers serious and imminent threat of harm. So before you're using or disclosing a person's COVID test results to another outsider, whether it's an employer, whether it's to other persons who may be infected and the like, you need to make sure that you do the analysis to make sure that you fit within one of the HIPAA exceptions that would allow you to make that disclosure. Don't necessarily just assume that because it's COVID, you can disclose it or use it however you need to. The government's issued specific guidance concerning media. I had this question this week. Media wants to come into the local hospital and do a story about COVID. The government warned about allowing media into the organization if they're going to be able to have access to any protected health information, or there's going to be any patients there or the like. So before you allow the media into your organization, make sure that you look at that particular guidance. Now, even though the general rule is that HIPAA still applies, even in the wake of the COVID epidemic, the government did waive certain portions of HIPAA. The government waived sanctions against hospitals, not other healthcare providers, but against hospitals for certain aspects of HIPAA, including the requirement to obtain the patient consent to speak with family or friends. They're not going to impose penalties against you if it's a COVID case and you need to talk to family members, or a requirement to honor the request to opt out of the facility directory. You're not necessarily obligated to distribute the notice of privacy practices if it's a situation where it's a COVID emergency. The patient's right to request privacy restrictions, the patient's right to request confidential communications. The government won't necessarily enforce penalties against a hospital if you violate those provisions for good COVID-related purposes. In addition, the government did indicate that it will exercise enforcement discretion in certain other areas that may impact HIPAA, including, they said, if you are a healthcare entity participating in a community-based testing site, that they may relax HIPAA requirements or will not come after you. They will exercise enforcement discretion in coming after you if your community-based testing sites don't necessarily measure up to all the regular standards that might otherwise be imposed by HIPAA. Even then, though, that only applies to the community-based testing sites, not necessarily testing back at the hospital or other clinics, things like that. In addition, they will exercise enforcement discretion and allow business associates to use protected health information for certain public health purposes without having to go back and get authorization from the covered entity. In addition, they've stated that they will relax the requirements for telehealth technology and allow healthcare providers, in order to render telehealth, to use certain platforms, even though those platforms may not satisfy all of the security rule requirements, as long as they're not open-facing and certain other requirements like that. So there are certain aspects of HIPAA that are relaxed during COVID, but the general rule remains that you still got to comply with HIPAA before you make unauthorized disclosures. The government has a whole website on the OCR page about the guidance that is issued concerning HIPAA and COVID, including certain bulletins and guidance about disclosures, for example, to first responders and the like. So you can access that at that website. a comment about reporting test results, because we've got a lot of clients, hospitals, other clinics that are contracting with, for example, employers to do employee COVID testing for them. And they assume that if they're being paid by the employer to do this testing, that they can automatically disclose those test results back to that employer or other person. That is not the case. HIPAA still applies. If you're a covered entity and you're performing that testing, then that is protected health information. That means that you generally need either the patient's authorization or another HIPAA exception that would allow you to go ahead and make that disclosure. The bottom line here is that you generally need or should obtain the patient's authorization that would allow you to go ahead and make that disclosure back to, for example, the employer or the university or whoever it is. If the person refuses to give you that authorization, unlike most cases, you can actually refuse to perform the test. So you condition that test on the provision of the authorization, because the whole purpose for doing the test is in order to make that disclosure. So in that limited circumstance, HIPAA allows you to condition the performance of the test on getting that authorization. If the patient still refuses, well, the employer could condition the patient's employment on that authorization and tell them that, you know, you as the healthcare provider, you can't disclose it without the patient's authorization, but the employer could terminate the person's employment if they fail to give the authorization in that situation. At least under HIPAA they can. Now, that applies if you're a healthcare provider and want to disclose the information to, test results to entities outside your organization. Obviously, you can disclose them to the extent that it is necessary to avoid serious and imminent threat of harm, or to a public health agency consistent with HIPAA requirements. Well, what happens if you are a hospital, for example, and are performing COVID tests on your own employees? Well, if you're performing that test, if you're doing that in your capacity as a healthcare provider, then HIPAA still applies to you. And the general rule is you cannot disclose that information or use that information for employment-related purposes unless you get the patient's authorization or, again, you fit within one of the exceptions like serious and imminent threat of harm or, disclosure for treatment and the like. So be careful about assuming that if you are a healthcare provider, a hospital, or a clinic and you're testing your own people, be careful about your ability to be able to use that for employment-related decisions. You need to make sure that you fit within one of the exceptions, or better yet, just get the patient's authorization. All right. Another issue that you need to be concerned about are business associates. Remember, HIPAA applies not only to covered entities, but business associates of covered entities. The general rule is that a covered entity may not disclose protected health information to the business associate unless you have a valid business associate agreement. Those business associates are the entities whom you are sharing the information with to perform a service by or on your behalf. It's generally those you pay to do something with your protected health information. If you fail to execute that business associate agreement, well, that's a HIPAA violation. But not only that, in recent settlement decisions, not necessarily over the past year, but in the prior year, there have been several cases where the Office for Civil Rights has essentially held a covered entity vicariously liable for its business associates violations because the covered entity did not have a business associate agreement in place. So, for example, there are a couple of situations where a covered entity contracted with a business associate. That business associate lost protected health information. Instead of going back against the business associate, the government went back against the covered entity and basically held the covered entity vicariously liable because they didn't have that business associate agreement in place. So to limit your exposure for whatever a business associate does, or if you're a business associate for what your subcontractor does, you need to make sure that you have an effective business associate agreement in place. That business associate agreement, of course, has to contain certain required terms that are set forth in the regulations. Over the past year, there have been several cases where the government's gone after business associates, including one business associate got hit for $2.3 million. Another business associate got hit for $1.04 million. The interactions, another situation, a covered entity got hit for for $100,000 because of a dispute with its business associate. So make sure that you get those business associate agreements in place and that they can contain the required terms. the Office for Civil Rights has issued a sample business associate agreement language. You can access that if you want to look at it. Personally, it's not great language, and I usually opt for different language. That brings us to next. The next lesson we learned from the government's action is that right to access. As I mentioned, last year the government initiated an initiative to enforce the patient's right to access their protected health information. So far there's been 12, as of this morning, 12 different settlements that have come out because of covered entities' failure to comply with their obligation to provide patients or personal representatives with access to the relevant records. Those penalties that have been imposed or the settlements that have come out so far range anywhere from $3,500 up to $160,000. They cover all sizes of entities, anywhere from healthcare systems down to even just, solo practitioners. So all of you need to make sure that you are aware of the rules for the patient's right to access and that you comply with those. In general, the patient or the personal representative generally has a right to inspect and obtain a copy of their protected health information that's maintained in their designated record set, which are basically any records that are used to make decisions concerning the patient or the patient's health care or payment for their health care. That includes not only records you create, but records that you receive from other healthcare providers that they created. A lot of people have a misunderstanding. They think you can't produce records that you got from other providers. That is not the case. To the contrary, HIPAA would require you to release that if it's within the designated record set, i.e., those are records you would rely on to provide health care to the patient. You've generally got 30 days to respond to requests. You can get additional time if the records are stored off-site and you notify the patient. You must provide the records in the form or format if it's readily producible, including electronic form. You may require the patient to submit a written request for those records, but you can't put in place unreasonable hurdles to allow them to get that or submit that request. You may charge a reasonable cost-based fee for the records, but that can only cover the cost of the actual labor and materials in making the copies, not additional administrative or overhead fees, things like that that are intended to discourage requests. If you get a right to request to access protected health information, make sure make sure that certainly is handled by the right person, that it goes to your medical records people. In addition, if you're going to deny a request to access information, you really ought to discuss that with the privacy officer first and make sure that it's appropriate. There are limited circumstances where you can deny the right to access, but that is very limited circumstances. In a somewhat poetic statement, OCR Director Severino emphasized the need to comply with that right to access. For too long, healthcare providers have slow-walked their duty to provide patients their medical records out of a sleepy bureaucratic inertia. We hope our shift to the imposition of corrective actions and settlements under our right of access initiative will finally wake up healthcare providers to their obligations under the law. Elsewhere, he stated the doctor's offices, large and small, must provide patients their medical records in a timely fashion. We will continue to prioritize HIPAA right of access cases for enforcement until providers get the message. Well, hopefully you've now got the message. You're going to make sure that you comply. The government issued a few years ago guidance concerning the individual's right of access. This is a really important document because I think they may have gone a little bit beyond what the HIPAA regulations actually require. But nevertheless, this is how the government is interpreting that right to access. If you haven't read that already, you really do need to call that up and go through it. It's got a series of discussions, addresses various issues, everything from what do they have a right to access, when can you deny it, how much you can charge for records, what form and formats you can provide, all sorts of things like that. So I'd highly recommend that you get that and you're familiar with it. It really is must reading for any healthcare entities. A couple of the issues when you look at the settlements over the past year that have come up in the context of the right to access is sometimes people misunderstand who personal representatives are or what their rights are. In general, under HIPAA, the personal representative, you treat them as if they are the patient. That means that the personal representative has the right to exercise the rights that the patient has. That means the personal representative generally has a right to access those protected health information just like the patient would. That personal representative is a person with the authority under state law to make healthcare decisions for the patient, or in the case of a deceased person, the deceased patient's estate. So you want to know who the personal representative is for purposes of HIPAA, you have to know who under your state law has the authority to make healthcare decisions. If they have the authority to make healthcare decisions for the patient, they also have the right to access the information they might need to make those decisions, and they are the personal representative, and you must treat them as if they were the individual. There are limited circumstances where you can refuse or decline to treat the personal representative as the individual, primarily in situations where it's not in the patient's best interest because it could pose a threat. Maybe the personal representative is abusing the patient, but those are really limited circumstances. General rule is you have to honor requests from the personal representative just like you would the patient, and therefore it's necessary for you to understand who is and is not a personal representative. Another couple of the cases came out this past year involved misunderstanding concerning psychotherapy notes. Requests went to mental health care providers, and the mental health care providers said, well, we don't have to disclose mental health records. That's all psychotherapy notes. That is not correct. HIPAA does create an exception that says that patients are not entitled to access their psychotherapy notes, but psychotherapy notes are a very defined, limited set of records. It's basically just those records that a mental health care provider uses to document its psychotherapy session. It's its notes from the psychotherapy session, and those are kept separate from the other records. It's not all medical records, mental health records. It's not prescriptions. It's not progress notes. It's not other records, other mental health records. So HIPAA generally gives the patient the right to access all of those mental health records except psychotherapy notes. So don't be caught like a couple of those healthcare providers who improperly withheld their mental health records from the patient under the mistaken belief that they could do so. There was a recent case that came out in January that affects the right to access. In the guidance that had come out from the Office for Civil Rights, they interpreted the HITECH Act requirements that require you to provide copies of electronic health records to individuals or to third parties that were designated by the individual. They extended that to not only electronic protected health information, but all records. And they said that's part of the right of access. And therefore, the patient would have a right to have you direct you to send their, even their paper records to a third party. And you would have to comply with all the rules that apply to the patient's right of access, including the timeliness of the response and the limits on the compensation. In the SIAX case, the federal court said, no, that's not supported. That's contrary to the HITECH Act rules. HHS went beyond its rulemaking authority when it issued that guidance. So now the rule is, in the wake of SIAX, if you're talking about electronic protected health information and electronic health record, if the patient comes in and wants you to send a copy of that electronic protected health information to a third party, then you must do so. That is part of the patient's right of access, and you've got to respond within 30 days, but you're not limited to the reasonable cost-based fee. You could charge them additional reasonable amounts, consistent with HIPAA requirements as well as state law requirements. Now, that only applies to electronic protected health information. If a patient wants you to send paper copies of their records, that same rule doesn't apply. Under HIPAA, you're not required to send those records to a third party per the patient's request. You could do it if you want to, but you're not required to. If the patient says, well, then give it to me and I'll send it, well, you have to give it to the patient, but you're not required to affirmatively send that to the third party. Because you're not required to send that to the third party, the same time limits don't apply, and again, you're not limited to that reasonable cost-based fee if you're going to send those records to a third party. So just beware of that nuance. All right. Next lesson that we learned from all of those cases is it is critically important that you respond promptly to problems and violations that may occur in the HIPAA context. The HIPAA rules specifically require that, for example, the security rule states that covered entities and business associates must respond to suspected or known security incidents and mitigate to the extent practical harmful effects of security incidents that are known. In the privacy rule, it confirms that covered entities are required to mitigate to the extent practicable any harmful effect that is known to the covered entity of the use or disclosure of protected health information in violation of the policies and procedures or the requirements of this subpart. So you can't hide your head in the sand. If you do, you may get smacked on the side of your head by the Office for Civil Rights. Look at some of the recent settlements that came out this year. For example, in a couple of cases, the government levied fines. Part of the reason for the government to go after those individuals were, for example, in one case, the FBI had warned the particular entity that they were the target for hacking a hacker, but the entity didn't do enough to protect itself. In another case, a reporter actually warned the clinic that its records were out there on the internet available for sale, but again, the clinic failed to act in a timely manner and allowed that hacker to continue to access those records for a certain period of time, even after the clinic found out about it. In other cases, the government or the covered entity or business associate failed to take action, even though the Office for Civil Rights had warned them that what they were doing was improper. The lesson there is that if the government tells you to do something, you better not just ignore it. Now, it's important to remember that initially, the government's kind of fallback, its primary way for addressing HIPAA violations isn't necessarily to impose penalties. Instead, by rule, they state that their primary goal is really to provide technical assistance first. They want to come in there and help you to comply. Now, that doesn't mean that they can avoid the penalties. If there's willful neglect, they have to impose penalties. But other than that, if it's not willful neglect, their first impulse is to come in there and try to work with you to get you to comply. If you fail to do that, though, if you fail to accept their technical assistance and continue to violate, then the government can jump all over you with both feet. For example, in a lot of those failure to respond cases, in those right to access cases, in the majority of them, the covered entity continued to refuse to provide the patient with access to their information, even though the Office for Civil Rights had given them prior technical assistance, and they still ignored it. Again, the key here is if the OCR tells you to do something, don't ignore it. Make sure that you follow up and you put the right steps in place. If you fail to do that, then that could constitute willful neglect. And remember, if you engage in willful neglect, the government has to impose penalties. The government must initiate an investigation for cases involving possible willful neglect, and if they find out it exists, they must impose those penalties. Willful neglect means the conscious, intentional failure or reckless indifference to the obligation to comply with the administrative simplification provision violated. It's that kind of willful response. You refused even though you knew. The government gave the following example in the breach or the HIPAA enforcement rule. Let's say a covered entity disposed of several hard drives containing electronic protected health information in an unsecured dumpster in violation of HIPAA. HHS's investigation reveals that the covered entity had failed to implement any policies and procedures to reasonably and appropriately safeguard protected health information during the disposal process. Well, HIPAA requires you to implement those things. If you just ignore it and you don't have the right rules in place or you don't have any rules, hey, that could be willful neglect and result in those penalties. That brings us to the final lesson, which is to make sure that you have those required policies and procedures in place, those required safeguards. In all of the cases that have come out, one of the factors that the government looked at was, hey, did they have the policies and procedures in place? If they didn't, then guess what? We're going to look, that could be willful neglect, and we can go after you for penalties. The required policies are set forth in the privacy rule, security rule, and breach notification rule. Make sure that you're familiar with that. At some point, it's probably a good idea to go back and compare the rules to your policies and make sure that you have policies addressing each one of those rule requirements. In addition to the specific rule requirements, make sure that you have HIPAA-compliant forms. For example, your notice of privacy practices, your business associates, your authorizations, those have to contain certain required elements that are mandated by HIPAA. If you don't, then they may not be compliant with the HIPAA. And be careful because those forms, as well as your policies, may morph over time, intentionally or unintentionally. And so it's a good idea periodically to go back and compare what you've got to the actual HIPAA requirement. Among other things, in the documents that we've got on our website are checklists to help you compare, for example, your notice of privacy practices, business associates, or authorizations against the rule requirements. If you haven't updated your HIPAA policies or procedures or your forms since 2013, since before 2013, well, you're probably out of compliance already because 2013, the omnibus rule required you to make certain modifications to your policies. Now, let's say you do have all of those policies and procedures in place, but you still have an employee who does something wrong. The benefit there is that that's probably not willful neglect, and you may be able to avoid HIPAA penalties. The government gave the following example in their enforcement rule. In this example, a hospital employee accessed the paper medical record of his ex-spouse while he was on duty to discover her current address for a personal reason, knowing that such access is not permitted by the privacy rule and contrary to the policies and procedures of the hospital. HHS's investigation reveals that the covered entity had appropriate and reasonable safeguards regarding the employee access to medical records and that it had delivered appropriate training to the employee. Under these circumstances, the government said that even though the employee acted with willful neglect, the hospital did not, because the hospital had the required policies in place. It provided the training, and you just had a rogue employee. And as long as the hospital responds appropriately to that, then that is not considered to be a willful neglect. And if the hospital corrects the situation within 30 days, they can avoid those HIPAA penalties. So once again, I want to emphasize the importance of making sure that you've got those appropriate policies and procedures in place and you've trained your people. In the documents we provided or made available on our website, we actually have a checklist that you can go through of the required rules under the privacy rule and also the security rule and the required elements for your policies, so you can compare your policies to the requirements of the regulations if you want to access that. All right, finally, let's talk about reporting breaches of unsecured protected health information. One of the requirements is that you take appropriate steps to mitigate, and under the breach notification rule, you've got an affirmative obligation to report breaches of unsecured protected health information. If you fail to do so, again, the government can come after you. There are a couple of cases. In fact, these were the biggest cases, the biggest dollar fines outside of, hacks that involved thousands of records. These were situations where the entity had the breach, but it, for one reason or another, decided not to or failed to timely do the breach notification. The government wasn't amused, and in both cases, they had to pay over $2 million each for those violations. Again, Director Severino said, HIPAA compliance depends on accurate and timely self-reporting of breaches because patients and the public have a right to know when sensitive information has been exposed. When healthcare providers blatantly fail to report breaches as required by law, they should expect vigorous enforcement action by the Office for Civil Rights. For determining whether or not a breach is reportable, the key is understanding the definitions that are involved. You have to report a breach of unsecured protected health information. Well, what is unsecured protected health information? Essentially, in electronic format, it's those records that are not encrypted. The only other way that you can secure protected health information is completely destroy them, which, of course, if you completely destroy them, it's kind of hard to see how they can be disclosed anyway. So really, we're talking about encryption for electronic data. If you have secured data, if the data is properly secured and you lose it, for example, lose a laptop or the like, but it's properly secured, that's not a breach of unsecured protected health information, and so it's not reportable. So that's why it's important to make sure that your electronic data is secured. Now, you only have to report if there's a breach of unsecured protected health information. Well, what's a breach? A breach is the acquisition, access, use, or disclosure of protected health information in violation of the privacy rule. Note that it only has to violate the privacy rule, not the security rule. That unauthorized access, use, or disclosure is presumed to be a breach and reportable unless the covered entity or business associate demonstrates that there's a low probability that the information's been compromised based on a risk assessment of the following four factors, and then it's that four-factor test that you're familiar with, including the nature and extent of the information involved and so forth. If you determine that there has been a breach of protected health information, then you've got to notify the individual within 60 days, HHS. You also have to notify them, but the only difference is the timing. If the breach involves 500 or more persons, then you have to notify them within 60 days, and then your name goes on the HHS wall of shame. If the breach involves less than 500 persons, then you can wait and notify them 60 days after the end of the next calendar year. Now, an important point about this 60 days, you have to notify the individual within as soon as possible, but no longer than 60 days. That means if you complete your investigation within 2 weeks, you need to notify them at the 2-week mark. You can't just simply sit back and wait for the 60 days. If the breach involves more than 500 persons in a particular state, you also have to notify local media. How do you make that report to the individual? Well, you have to send them by first-class mail unless you get their permission to send it by email. How do you notify the government? Well, you go to the government's website here and you submit a notice of breach per this electronic link, and it'll walk you through the steps. As I mentioned, if your breach involves more than 500 persons, you go on a list on the government's website of all those entities that have had breaches involving more than 500 persons. A couple of points on this, on the failure to report when you should have. The government gave the following example in the HIPAA enforcement rule. A covered entity's employee lost an unencrypted laptop that contained unsecure protected health information. HHS's investigation reveals the covered entity feared its reputation would be harmed if information about the incident became public and therefore decided not to provide the notification as required by the rule. The government concluded in that situation that is willful neglect. That means that even though they may not have been subject to willful neglect penalties for the underlying breach, the failure to report the breach itself constituted willful neglect and could result in those mandatory penalties. So in a lot of cases, the failure to report is worse than the underlying breach. When in doubt, it's usually better off reporting, because if you do the report, chances are it's not willful neglect and the government will never do anything about it. On the other hand, if you fail to report when you should have, then the chances are greater that if the government finds out about it, that they will find willful neglect and they'll come after you. Another comment about that example that they gave, note that this involves the loss of an unencrypted laptop. The government generally takes the position that if you lose an unencrypted laptop or USB, you can't account for it, even if you don't know that it's stolen, then that is presumptively a HIPAA breach that you're going to have to report. You want to be very careful about situations where you lose unencrypted data, because chances are you're going to have to report. If you fail to do so, then that will likely be a HIPAA violation. And elsewhere, the government said that if you do lose a laptop and subsequently you get it back and you do a forensic analysis and shows that it hasn't been nobody else has accessed it, then you may not have to report there. But if you never get it back, you can't do that analysis. Again, the assumption is if you've lost unencrypted data, electronic protected health information on a USB, on a disk, whatever, that's going to be reportable. And that could result in fines and penalties to you, because encryption is an addressable standard. Again, we get back to the point that for all of your mobile devices, make sure that you're encrypting that data. All right. That is a brief overview of some of the lessons we learned from the government's recent enforcement action, some of the top things you need to do in order to protect yourself. If you want additional information or help, you can go to the government's website, just type in OCR and HIPAA, and it'll take you here. They've got a lot of great resources. In addition, as I mentioned, we've got free resources on our website, a lot of stuff on HIPAA. I write and speak a lot on HIPAA issues, and those webinars and publications are available for free on our website. If you have any questions for the program today, by all means, feel free to submit them using the chat feature, or shoot me an email, and I'll try to respond to those as soon as I can. Other than that, thank you very much for your participation as always. I hope you're doing well and that you guys stay safe in these very troubling times.